Just stopping. Is that okay?
Yeah, there's people that are concerned because you've been out here for a couple hours. They want to make sure you're okay.
Okay.
You got some ID on you?
Yeah, I do, but
Going to provide an ID. I'm going to no. Keep your door open.
Okay.
I'm going to know who I'm talking to.
I just want to let you know
ID.
I'm not a threat to you guys. I have no weapons.
Okay, great.
I'm just reading a book in my car.
Sir, we could have been. Yeah, they want a barn.
You want to borrow him?
Yeah.
I'm trying to explain to you the nature of our investigation.
So here's the thing, sir. All right, we're gonna go to jail. All right, put your hands on your back, please. Thank you.
We now have an update to Mr. Cho's story. If you haven't seen the video, definitely go check out the full video. But here is a quick breakdown of the entire story. Mr. Cho was traveling from New York to Georgia when he hit a sudden rainstorm and decided to pull over into a gas station to wait out the storm. While there, he moves to his back seat and begins reading a book.
I'm just stopping for the... Just stopping. Is that okay?
Yeah, there's people that are concerned because you've been out here for a couple hours. They want to make sure you're okay.
Okay.
You got some ID on you?
Yeah, I do, but I can move if you want.
You don't. I'm not saying you have to.
I'm just resting.
I know. I'm not accusing you of anything. They want us to check on you. I just want to know who I'm talking to. That's all.
An employee at the store notices Mr. Cho's car there and decides to call the police because he's been there for a while. When the police arrive, they immediately begin to essentially interrogate Mr. Cho and demand that he shows them his ID.
I'm just passing through, sir.
Okay. I need your ID.
Did I commit a crime?
You're loitering.
If I'm trespassing...
Yes, you are, because you've been here for hours. Okay. I need your ID, sir.
Are you gonna arrest me?
Do I need to?
I don't know. I didn't.
Okay, you need to identify yourself. Please provide me your identification.
Officer, if I committed a crime,
yes, it's called trespassing and loitering. That's a crime.
I don't believe I've been trespassing.
Okay, it doesn't matter what you believe. You need to provide your ID.
All I was doing, officer, was reading a book.
I need your ID.
I mean, you're gonna arrest me because...
If you don't provide your ID, I will.
Just for parking my car?
For trespassing and loitering. You've been here for hours. That's not normal behavior. It's not normal behavior. I need your ID.
I don't know what you mean by normal behavior. Is that
people don't park in gas stations for hours. They come get gas and they leave. They come to the store, grab something and leave. You've been here for hours. I need your ID.
I've actually been doing this for...
Give me your ID or you're going to be detained.
You're gonna arrest me?
Potentially, yes. I'm trying to provide you an opportunity. No,
car?
I already explained to you why we're here. Provide your ID.
Sir, I didn't do anything wrong.
Provide your ID.
I'm not required to provide...
Yes, you are when we're investigating a complaint.
No, you're not, sir. Can I talk to the sergeant?
Yeah, sure.
Okay. I'm gonna get out of the car, okay?
They accuse him of trespassing and loitering simply because he was in his car for a few hours. Mr. Cho never even entered the store to let alone have been trespassing in the store. Mr. Cho knows his rights and resists against what these officers tried to do to him and refuses to give his ID because they had no legal or legitimate reason to demand and receive it. Mr. Cho is then arrested after the officer solicits a trespass from the employee of the store.
Morning. I don't know. He's being difficult. Do you want to bar him?
Not like good morning, huh?
He's coming from. He's not even from here. He's from New York. So I don't know what he's got going on.
I mean, I wasn't even gonna call him, but it's like every weekend. This is something that's happening to me.
Yeah,
like
happened last weekend. The weekend.
Yeah, last Saturday,
Okay.
guy was sitting on pump 7 for about an hour.
Yeah, no, that's not normal behavior. I agree.
It's different.
And he's been out there since about 5:45.
Okay.
For sure.
I mean, it
I'll be
was
back at
pouring
12.
down raining, so I was like, maybe they just needed to pull over, but hell, come here and say something. We open at 6 a.m. I don't know what the hell you doing.
Yeah, no, I get it. That's you tucked in the corner. It's like that's how things. I get it. Do you want to bar him or what do you want to do?
I mean,
You can. It's up to you. I mean, I don't work for the store. You.
I mean, he hasn't came in here and did anything, but I don't want to bar him for no reason. But hell, I need him to get off this property.
Okay.
Go somewhere else. But
Okay.
I probably should go ahead and bar him because he's gonna come back and say you're the one called the cops on me. Probably.
I mean, I don't know this guy. He's not from here. He's from New York. So.
You can bar him. I
You
really
want to
take
bar
this hard.
Okay.
I'm scared.
I get it. It's a crazy world we live in.
Especially on the east side.
Let me jump in here quickly to say thanks for watching this video. Please like, comment, share, and subscribe for more content like this and to allow this channel to reach more people. Back to the video now. You can see that the officer never actually gives the employee the full story, that he stopped because of the rain and that they found him just reading a book in the back seat of his car. He probably knew that if he told her this, she wouldn't have any reason or inclination to bar him. But he withholds this information, and the employee, thinking he's some suspicious person, goes along with the cops and decides to bar him.
Yeah, they want to bar him.
You want to bar him?
Yeah.
I'm trying to explain to you the nature of our investigation.
So here's the thing, sir. They want to bar you from the property, okay? That's on them. That's their right to do. Okay. So in order to do that, at this point in time, it is a criminal trespass warning, okay? It's not an arrest. However, it is something where we do need your ID so that we can fill out the paperwork and officially make it that you are barred from this property, okay? So at this point in time, because they want to do that, we are going to need your ID.
Okay, I just need to fully understand what's going on. So I parked my car here during the rain. They called you, I don't know exactly when, but when you guys arrived, you asked for my ID.
Mm-hmm.
I refused to give my ID because I didn't believe I did anything wrong. But now you went to the manager or whoever this person is, and they are asking for a bar. I'm just trying to explain what that is.
A trespass warning. So what they're doing is they are barring you, they are trespassing you from the property, which means if you return back here, then you will be arrested for trespass. Okay? And so for that process, we will need your ID. Okay?
So just so I understand, they're asking me to leave.
No, they're telling you you're not back allowed on this property. They're making an official report and documenting that you're not allowed on this property.
Okay, I haven't been here before.
It doesn't matter.
I'm just trying to understand.
You
Okay.
keep on trying to
You say you keep trying to understand, but we're explaining to you the process.
You just keep
Okay?
going in circles.
So and you keep going back to the point that we've already explained. All right? So here's the thing. We get your ID, we put it in the system, we trespass you from the property, you're on your way, you're never going to return here again, so it's not going to be a problem for you.
All right. We're going to go to jail. All right. Put your hands on your back, please. Thank you. Thank you, Father.
And now that he is barred, they want to use this as a basis to get his ID, which also tells you that they never had any reason to get it from him in the first place when they were demanding it from him. We also covered in the last video that for all the talk of trespass and loitering that these officers kept mentioning over and over, they couldn't actually charge him with either of those and ended up charging him with obstruction of officers. We now have a big update in this case where a judge has ruled on whether the officers did the right thing when they stopped and arrested this man. We'll go over the actual decision and explain everything in it so we clearly see what happened here. Let's first lay out how a criminal case works so we're all clear on the timeline of events. After someone is arrested on charges, they then later are officially charged by the state or county in which the alleged crime occurred. This can be the district attorney's office or the state's attorney. After being officially charged, you then move on to being arraigned, which is the first time you come before a judge and typically enter a non-guilty plea. From that point forward, you engage in discovery and the prosecution sends over all the evidence they have and possibly engage in some plea discussions. If it looks like no plea agreement will be reached, the court sets a trial date. Before the trial, the defense has an opportunity to file motions to dismiss or suppress evidence. Essentially, that means that if there's something obtained by the police to be used at trial, both sides get to argue if it was legal or not and should be allowed in court. And this is what we have here for Mr. Cho. His attorney filed a motion to suppress on the basis that there was no reasonable suspicion for the stop in the first place. Let's read it here right now. On July 22nd, 2025, this matter came before the court for a hearing on defendant's motion to suppress. Defendant has been charged by accusation with 1 count of obstruction. On February 16, 2025, in Clark County, Officer John LaValle of the Athens-Clark County Police Department responded to a 911 call from a clerk at the Murphy USA gas station on Lexington Road. The clerk reported that a vehicle was parked at the gas station for a prolonged period of time and that she wanted an officer to check on its occupants. After making contact with the defendant, Officer LaValle requested the defendant provide his identification, which the defendant eventually declined to provide. The defendant was thereafter arrested on the obstruction charges and transported to the Clark County Jail. At the hearing, the court heard testimony from Officer LaValle, and a copy of Officer LaValle's body camera footage of the incident was admitted into evidence. Furthermore, the state offered into evidence the 911 call made by the clerk. As the basis for his motion, defendant seeks to suppress evidence allegedly obtained in violation of his 4th and 14th Amendment rights. Specifically, defendant challenges reasonable articulable suspicion for the stop. After consideration of the record, applicable law, argument of counsel, and for the reasons set forth on the record at the hearing, the court finds and orders as follows. A brief investigative stop must be justified by specific articulable facts sufficient to give rise to a reasonable suspicion of criminal conduct. The suspicion need not meet the standard of probable cause, but must be more than the mere caprice or a hunch or an inclination. During the initial 911 call from the clerk at the Murphy USA gas station on Lexington Road, the clerk states that a car has been sitting in the parking lot for over an hour and that she does not want to approach the vehicle. After giving the 911 operator a description of the car, the clerk states, "I don't know if they are handicapped or if they fell asleep or if they are okay. I don't know what they are doing." After the operator asks the clerk if she wants the car to leave, the clerk initially agrees, but then clarifies, "I guess I'm rather trying to make sure they're okay. There's too much going on in the world now. They haven't come in and said anything about needing to sit there for a while, so I don't know why they're there." After independently evaluating the initial 911 call, the court finds that the call was made primarily out of concern for the safety and well-being of the occupants in the vehicle, not for the purpose of reporting suspected criminal activity occurring on the property. The clerk indicated that she wanted an officer to check on the individuals in the vehicle because they had been parked there for some time. Even if the 911 call could be construed as a report of suspected criminal activity for the reasons discussed in more detail below, this 911 call fails to provide articulable facts that give rise to suspicion of any specific criminal conduct. Certainly, defendant's mere presence in his car at the gas station parking lot, even if for an extended period of time, is insufficient standing alone to suspect criminal behavior. Officer LaValle was dispatched to the gas station in response to the 911 call and arrived on scene in his marked patrol vehicle, armed and in uniform. Officer LaValle proceeded to park directly next to defendant's vehicle and very quickly made contact with the defendant, who was alone, seated in the rear passenger side of the vehicle. The defendant told the officer he was stopped there waiting for the storm overhead to pass. In reviewing the Axon video, Officer LaValle can be seen explaining that he had been dispatched to the gas station because those people are concerned and want to make sure you are okay, as the defendant had been there for a couple of hours. Officer LaValle immediately follows up to ask if the defendant has ID on him. The defendant thereafter offers to move his car. Officer LaValle replies that defendant does not have to move and further says to the defendant, I am not accusing you of anything. They just want us to check on you. After defendant states that he is merely passing through and asks if he has committed a crime, Officer LaValle's demeanor and tone of voice change. This portion of the encounter starts when Officer LaValle tells defendant that he needs your ID. Defendant then asks if he has committed a crime, and Officer LaValle responds with, you are loitering. Defendant begins to ask a question regarding trespassing and is cut off when Officer LaValle interjects to say, yes, you are, because you have been here for hours. I need your ID, sir. Defendant asks again if he has committed a crime, and Officer LaValle responds, yes, it's called trespassing and loitering. That's a crime. After some further back and forth, Officer LaValle tells the defendant that he needs the ID because he has been here for hours and that is not normal behavior. In light of the facts set forth above, the court finds that Officer LaValle elevated the encounter into a second-tier detention at the time he accused defendants of loitering and trespassing. Less than a minute from Officer LaValle's arrival at the scene and less than 30 seconds into his recorded conversation with the defendant. Based on the totality of the circumstances at that point, including the fact that the officer stated to defendant twice that he had committed crimes, loitering and or criminal trespass, no reasonable person in defendant's position would have felt free to terminate the encounter. This clearly had elevated to a seizure that required a particularized and objective basis for suspecting that defendant was or was about to be involved in criminal activity. However, at this point in the encounter, a second-tier detention could not be justified based on the 911 call or Officer LaValle's limited personal observations at the scene. While Georgia appellate courts have held that 911 calls can form the basis underlying reasonable suspicion for a second-tier investigatory stop, here, based on this particular 911 call, Officer LaValle did not have reasonable articulable suspicion that defendant was committing any criminal offense. Georgia's loitering or prowling statute provides in part, a person commits the offense of loitering or prowling when he is in a place at a time or in a manner not usual for law-abiding individuals under circumstances that warrant a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. Applying the statute to the fact scenario here, Officer LaValle approached the defendant in his vehicle. The defendant opened the door, at which point Officer LaValle asked if he was okay, to which the defendant replied that he was. At the time this incident occurred, it was visibly raining in the area, and immediately upon contact with Officer LaValle, the defendant explained that he was waiting for the storm to pass overhead and that he was resting. That explanation is sufficient to explain defendant's presence and dispel any reasonable alarm. Applying the standard for reasonable suspicion above, there is nothing that would indicate a reasonable suspicion of criminal activity that could questionably fall within the parameters of the statute. Officer LaValle repeatedly tells the defendant that his behavior is not normal behavior, specifically for an individual to be parked at a gas station for such a long period of time. However, not normal is not the standard and does not in and of itself equate to criminal. At the point Officer LaValle first told defendant he was committing the crime of loitering, the officer had only been at the gas station for less than a minute and had only been speaking with defendant for less than 30 seconds. Neither the 911 call nor Officer LaValle's observations at the scene warranted a justifiable and reasonable alarm or immediate concern for the safety of persons or property in the vicinity. As the Court of Appeals noted in Lewis v. State, an officer's feelings that a person is acting in a suspicious way does not amount to a particularized and objective basis for suspecting him of criminal activity. It appears Officer LaValle was operating off some hunch or inclination that the defendant was loitering based on the length of time he had been parked at the gas station. While the court does not necessarily agree with Officer LaValle in his assessment that such action is not usual for law-abiding individuals, even if it were, Officer LaValle had no affirmative evidence that any of defendant's actions warranted a justifiable and reasonable alarm or created concern for the safety of persons or property in the vicinity. After review of the evidence and testimony presented, the court does not find that Officer LaValle's second-tier encounter with the defendant was justified by reasonable articulable suspicion. While later conversations between Officer LaValle and the clerk may have supported some inference that defendant was loitering or trespassing on the property, Officer LaValle had already elevated the encounter to a second-tier detention prior to gathering such information. If Officer LaValle had developed this information during a voluntary first-tier encounter, the outcome would likely have been different. All interactions between the officers and defendant that occurred as a result of the unlawful second-tier detention, starting when defendant is accused of the crime of loitering, are excluded. For the reasons set forth above, defendant's motion to suppress is granted. So as we can see, the court basically echoed what we already said and thought, because the officers had no reasonable basis to even stop and question Mr. Cho. Everything after that was impermissible and illegal. The clerk's call never inferred any possible criminal behavior, but just that she wanted to have Mr. Cho checked on. And Mr. Cho quelled any possibility of criminality when he freely spoke to the officers and explained his presence at the location and why he was in his car for such a long period of time. So despite all their assertions that you must provide ID because they are investigating a crime, that all amounts to nothing, especially when you don't even have reasonable suspicion that any crime exists. What is most sad is that Mr. Cho has had to go all the way in getting a lawyer to represent him and argue this motion before a judge, all to prove what we already knew just from seeing the video. Despite this ruling, these officers, especially Officer LaValle, are probably not going to face any repercussion for their actions because the county essentially signed off on them when they reviewed the evidence and decided that they would move forward with the prosecution when they could have dismissed this from the very beginning without a judge needing to get involved. So it's very disappointing that the prosecutor's office that should impartially review evidence it receives before moving forward with charging someone would be willing to co-sign a blatant violation of someone's rights. Mr. Cho has indeed filed a civil lawsuit at this time, and I will be periodically checking for updates to see where exactly it all stands. So don't forget to subscribe and stay tuned on any new details, as well as to see what other stories we bring on this channel for your legal edification. And consider becoming a member as well for added benefits as we continue to grow on this channel.